All right, welcome back to the program. Mark Mix, National Right to Work Foundation, is on the program to talk about what's going on in the world of union shenanigans. Hey, Mark, it's good to have you on the show.
Good to be on again, and good to hear "Carry on my wayward son." That's good advice these days.
No kidding. Well, Mark, let's talk about, I guess this is reasonably good news. We had the National Labor Relations Board help workers. Usually when we talk about the NLRB, we're talking about the NLRB putting forward some rule or some new amendment to a rule that empowers unions. We actually had the opposite happen here recently.
Yeah, absolutely. They came out with rulemaking the other day, and the rules that they imposed here, the things that they're talking about, are employee rights. They're not business rights. They're not labor union rights. They're employee rights as they relate to how employees get in and get out of unions. And it's about time someone addressed these issues, because most of the stuff that we deal with these days is non-statutory. When they wrote the National Labor Relations Act, they put one statutory provision in regarding elections, and they said that if a union won an election, they could negotiate for a year before employees could try to throw the union out. That's the one actual statutory bar that's in the law. The rest of this stuff was created over the years, and they finally got to address a lot of it. And Vicki, I will say, a lot of these cases that they're citing in this rule are cases that the foundation won and has litigated over the years, helping employees. And that's the really important part of this. And the board has done a great job of helping to expand employee rights under the Act.
What are blocking charges, and how did the NLRB help here?
Yeah, blocking charges. Let's say, for example, you have a union at your company and a bunch of employees get together and they just say they want to decertify the union. They want to get rid of the union. Well, the moment that a union official hears that there's a decertification drive afoot, they can file any allegation they want against the employer saying, well, the employer is putting the people up to this and the employer did this and the employer did that, and that immediately blocks the election. So there'll be no election until, quote, these blocking charges are litigated. And, Vicki, you know about the litigation process. Basically, the NLRB investigates, and then, God forbid, if they file a complaint, that goes into litigation. And this can last. We've had cases that's lasted up to 6 years before the workers got to exercise their rights to have a vote to kick the union out. And all during this time, Vicki, guess who's collecting union dues?
Of course.
The union. Yeah. So these blocking charges, what they're saying now is that these blocking charges are going to be limited, and what they'll do, instead of it's not letting the employees vote, they're going to let them vote. They're going to impound the votes if there's still active litigation going on, but they're going to let them vote. What happened before is they'd say, we're not even going to let you vote, and we're going to let this process go. So if they find out that this allegation has no basis, they'll actually count the votes, and if the employees win, the union would be out.
That's huge.
It's an amazing case. Yeah, it really is. And so the blocking charges is one part of it. The other part, which is very interesting, you and I have talked about this before. Back in 2007, we represented some employees at a first-tier automotive supplier to General Motors, a company called Dana. And basically, General Motors put out a letter to all of their first-tier suppliers and said, you must be a good corporate citizen, and what that means is you must have a union contract in order to still supply parts to our company. So we had a lot of companies that recognize unions without even a secret ballot election, using what's called voluntary recognition, and they would just say, yeah, okay, we're now a union.
Wow.
What we won in 2007 was the ability for workers, if they were organized through this voluntary quote-unquote recognition, they could actually get a secret ballot vote to prove that they indeed wanted to be in the union. Well, the unions didn't like this, and the moment that the Obama board got in charge back in 2011, one of the first cases they overturned was our Dana victory, in a case that was ours too, called Le Mans Gasket. We were trying to exercise this power, and the board has finally said, you know what? The preferred method for unionization in this country is a secret ballot election. So they went back to the Dana precedent, which says if you're forced by card check into a union, you can trigger a vote and have a secret ballot vote to prove that that union has majority support. And if they don't, the union wouldn't get certified. That's a huge victory as well.
Can any of this be, let's say that if there's another administration, the NLRB makeup changes, can these rules revert back?
Well,
it's not statutory.
Yeah, right. That's the secret about rulemaking. Rulemaking is a little more solid, if you will, than a precedent. And, like the Dana precedent I just mentioned. As soon as a new board changed, it was like a tennis match. The ball goes over the net, then it's returned, and it goes over the net. Rulemaking puts it into kind of the lore of the board, and they would have to go through the same process. They'd have to go through a comment period and proposing the rule. People could comment, and it takes a longer process to overturn a rule. They could do it, but it's more difficult to do. And that's why rulemaking is kind of an important part of an agency's operation, because what they're saying is this is the way we are going to interpret the rule, and it's not just a precedent, it's the way we believe the statute should be read, and it's more permanent. So we think there's some foundational strength to this, and, if the unions want to come back in and say, yeah, we want you to be unionized, we don't want you to have a chance to vote, I mean, I know there's outrage and there's double outrage and there's triple outrage, but those types of things are just outrageous.
It's outrageously outrageous. That's what it is. That's triple outrage there, Mark. Let's talk a little bit about what the political goals here are of the union, and they're not even really making many bones about it. We saw that Phase 3 stimulus. Nancy Pelosi attempted to insert a number of appalling expansions of union authority in that. The unions are flat out forcing Democratic candidates, including Joe Biden, to commit to doing everything in their power to eliminate the protections of state-passed right-to-work laws and any number of other things. So they think they may have their cat in the bag here in this upcoming election. I think they're probably thinking this economic downturn is probably a net positive for Democrats.
Yeah, Vicki, and that's really the unfortunate thing. And I think we've seen that from both union officials, not rank and file workers, of course, because they're the ones that suffer under an economy slowing down like this. But union officials think this is the best thing since sliced bread, and in fact, it's the thing they can use to beat Trump in the next election. And you're right, going back to the COVID-19 coronavirus issue and the Phase 3, there were several provisions in that bill that were written in kind of at the last minute in what was an 851-page bill that got passed in a matter of a couple of days, and there were things that we found in there, and working with some of the senators and Senate offices, there were a couple things that got in that ended up remaining in that are kind of concerning. But yeah, there was no question they were using the Rahm Emanuel theory of never let a good crisis go to waste.
Yeah, and this is, the unions. It's easy to see their tell. Their tell is they don't want to just let people vote up or down on whether or not to permit the union to organize. And their second tell is they do not want to come clean on the fact that in right-to-work states, they still enjoy a privilege of exclusive representation for the workforce. And again, if you can't just let people weigh in and say, sure, we want your representation, if you can't sell yourself strongly enough to workers and be comfortable with a secret ballot vote, be comfortable with freedom to choose whether or not to allow someone to be a middleman between your paycheck and you, that says everything about the value of union representation right there.
Yeah, that's exactly right. Back when we were litigating that Dana case, this was the time when union officials were using the corporate campaign. They were attacking employers, getting employers to capitulate to hand their employees over because, as one union official said, we don't do elections anymore. And what they meant was we can't convince workers to vote for us, in secret ballot elections, so we've got to take the weakest link in the chain, which generally is an employer. And I mentioned that GM corporate good citizen policy where they sent the letter out and said, you must be a good citizen. And a way to be a good citizen is to make sure your employees are unionized. That's the type of way that they're trying to expand their ranks, and that doesn't make any sense from a business perspective of selling a product that somebody wants to buy. Force feed me. I like ice cream, but I don't like it forced down my throat.
This has actually been a surprisingly, this administration, the Trump administration, has been surprisingly strong on worker freedom. At the beginning of the Republicans campaigning, when there were 16 Republicans and it all came down to Donald Trump, I wasn't sure. But he's been pretty damn good on this stuff.
He's been right. The justices there, the judges that he's appointing, the folks in the agencies are paying attention to this. And frankly, Vicki, the important part of this, what the NLRB did yesterday with rulemaking, is they stood up for America's employees, not the big business guys, not the big union guys. They stood up for employees. Everything in this rule talks about employee rights, and no one who looks at it and reads it and honestly understands what's happened here can say anything more than what Donald Trump has done, is said to workers, look, you deserve these rights. We're going to try to give them to you, and we'll try to protect them for you if we can.
Thanks for coming on the program. Mark Mix from the National Right to Work Foundation. Good to have you. Be safe.
Thanks, Vicki. You too.
Thank you very much, Mark Mix.